Uh, Thank you very much, everybody, for joining in this in the seventh, not seventh, actually, it is the fifth Go Just webinar. The series that we set in collaboration with the project Mitigation that is led by Sophia Efstathiou and the UNESCO Chair on Climate Change and Climate Diplomacy that is held by Professor Doussis in the University of Athens. Go Just is a project funded by the Hellenic Foundation for Research and Innovation. I'm Stathis Arakostathis, the PI of the project, and Go Just explore the issues of governance and justice issues in relation to agri-food transitions in Greece. In this fifth webinar, actually, we have the great pleasure and honor to have with us Andrea Borghini and Enrico Bonadio. Andrea Borghini is associate professor in the Department of Philosophy at the University of Milan, and Enrico Bonadio is reader in the law school in the City University at London. Today, there will be a joint, let's say, performance by both, and they will be talking on food and intellectual property rights between exploitation and empowerment. This is a very important topic, both for Go Just, because we deal with issues of intellectual property broadly defined and the knowledge management, particularly in relation to seeds in our case. But we know very well that intellectual property studies of intellectual property rights and the relation and the impact they have on food and food transition and transition is a very important, pertinent topic of research and a topic that really has an impact on agri-food transitions and the food politics and policies, and an impact in relation to just transitions in the food industry. I would like to thank both Andrea and Enrico for accepting our invitation to welcome them in the webinar series. And Andrea and Enrico, the floor is to you. Thank you very much.
Thank you. Thanks to you, Stathis, and to Sophia, your colleagues, for this very nice invitation. And this is going to be for Enrico and myself the first occasion to present this book. I can show it. That's going to be the basis, of the discussion today. And we're going to proceed basically by explaining a little bit the field, food and intellectual property rights that we tried to cover in this book, and the way in which we tried to cover it, and then give some examples, and hopefully then that will lead to some interesting questions, conversation. So the field of food and intellectual property rights is pretty widespread. And it encompasses questions such as, maybe even in a dinner party, every now and then people come up with the question, can you really copyright a recipe? Is it possible? And usually a person says, no, you can't copyright recipes. And then, slowly someone starts saying, oh, maybe you can copyright part of a recipe and so on and so forth. Right? And then you enter into the details of the debates. Or sometimes people think, oh, why are there geographical indications? Do we really need them? What is the rationale behind them? Why they were introduced in the first place? Do we want them, and so on and so forth? Some of these questions have been also discussed, taken up in different ways, also in media, from newspapers, magazines, and even sometimes on TV programs, in connection to questions such as menu scraping, fraudulent or not so explicit representations or appropriations, one could say, sometimes of recipes, and so on and so forth. So what we will see, what you have when you're dealing with the IP rights in the food domain is that there is really a broad field of negotiations that one could see as culture negotiation. And in part, I think this is the approach we take in the book, or at least that's what I'd say. And it's an approach that is led by let's call it philosophical effort, and some of you could think it's more broadly intellectual, and not only philosophical. So when we are thinking about food and IPs, I guess the first thing that could come to mind is just that, in the end, IPs are a form of commercial exploitation, right? So one could remember going around Chianti with one of my children when he was like 3 or 4, and at some point he said, "Baba, why is there this rooster everywhere?" And that's the rooster of Chianti Classico, because it's a geographical indication, right? So it's some sort of IP, and they really exploit it. Clearly, if you go to Florence, it's everywhere, right? And these are the cases where I think the effects of having IPs, it's really under the sun. Everybody knows about these cases, right? And so if you are thinking about food and IPs, you want to have a discussion, clearly you include these cases that are under the sun. And there are plenty of them, of course, and this is just one of them. But then there are also some other cases that are a bit more latent, one could say. And so some people might know about them, but not everyone, right? So if you think of Ritter Square, famously, they even advertise themselves as the art of the square, and the fact that it's so iconic, this square, is indeed tied to a patent issue and a patent dispute that we also cover in the volume. But there are also other cases of patents that they didn't lead to cases, so we are now, for example, reviewing them in the book, but they're quite curious or iconic. So Fudgy the Whale, this cake, that was relatively popular in the US, in part it still is. It is protected, by an IP. Quite recently, I just put here a Guardian article, recent Guardian article, that was talking about this is from maybe 5 years ago, if I remember correctly. It's like the official cronut recipe, and the cronut is this, partially croissant, partially donut, invented by Dominique Ansel in New York City, or consider this Easy Scoop. Some of you might know, if you are maybe from Minneapolis, it's this ice cream shop that has a tiny scoop on top of a large scoop, and it's has a patent, on this. And so these are the cases, and those are very frivolous. Then some others could be a bit stronger, like in the case of Rittersport. In some cases they shape the market. In some other cases they come to maybe define more specifically a producer, even a local producer, but they perform a certain function without necessarily consumers knowing about it. Right? So what did we try to do in the book? When Enrico and I met, it was actually a few years ago at a conference on recipes, 6 years ago. and it was in 2018, we started discussing the issue of how food and IPs were covered in the literature, and especially certainly in the philosophical literature from a broader, let's say, theoretical point of view. And one thing we saw is that perhaps there wasn't or I would say, at least to our knowledge, there wasn't a map of the domain that tried to be comprehensive. And so that's one of the things that we set out to do. We said, okay, first of all, if we want to really try to work on this, we should try to map out the domain. And immediately, I would say we were confronted with at least two strategies. One could imagine others. And it would be interesting seeing that here there are a number of you, there are scholars also of history, of intellectual property, how in different domains, maybe, which kind of junctures, which kind of elements of the debate have been considered most important. So on the one hand, you could have a review of the issues of food and IPs following the main junctures provided by the law in different, in different countries or different, constitutions, and think of the type of IP rights, right? So it could be different kinds of patents, maybe trademarks, maybe you have trade secrets and GIs, and so we could have arranged the book in that way. And to some extent, we started reasoning perhaps also in those terms. We also consider other options. For example, we consider geographical option. We considered maybe option by type of products. But then in the end, what we thought was most interesting, at least for us, we were, and then in part, I don't know, maybe Enrico can confirm or not if that was more of my job, but I was trying to figure out what is a way in which we could, put together the legal expertise of Enrico and the literature that is available with someone like me that works on from a more, let's say, theoretical point of view, but of broadly cultural issues connected to food. And so the type of work we decided to do was precisely to describe what one could call the societal juncture that underline the disputes that have taken place in court, and in some cases we decided also to cover things that happen actually outside of the court, but they're still meaningful. That basically put together the literature or what happened in the field, of IP rights and food, with other ongoing debates, issues with that engage food scholars. Food scholars, they really look at food from the point of view of culture, ethics, and I would say tradition, and so on and so forth. So here you have really, as I quickly mentioned also now already, two different kinds of tools. Right? Here I call them legal tools. Some of you may want to be more strict when you use the term legal. You can also just call them tools. Some are softer, so to speak, so they're not necessarily legally binding in a court. Right? So if you take even the UNESCO Intangible Cultural Heritage, if something is listed in that entry, it doesn't necessarily, or it's unclear, to what extent this could bear specific legal, implications in a court in a country. Right? So we review in the book, for instance, we have two cases related to kimchi, one about production, and the other is about really naming an identity across border, the border with China. But kimchi is notoriously is not registered, it's not protected. But what is protected under what has been listed in the UNESCO is the practice of making kimchi in South Korea, the kimjang, and so that is an example, you know, of something that maybe doesn't get a certain kind of protection, but you know, the practice maybe does. And as we know, there are lots of other practices like that, like broad cuisines, like Mexican cuisine, or you know, the culinary French of the culinary meal of the French, and that are in that list. But there are also a number of other projects, so you can consider softer tools, even you know, repositories like the Arc of Taste by Slow Food, that I think is quite important and interesting, or labels like those you know, issued by organizations like Fair Trade and you know, the Rainforest Alliance and so on and so forth, as well as programs that were issued by specific countries. Like here on the top left, I have the some sort of evocation of the Global Thai program, you know, that led to the creation of thousands. I remember how many thousands, maybe 40,000, if I remember correctly, the last Thai restaurants, you know, around the world, sponsoring really a cuisine, but it wasn't legally enforcing, if you want anything specific. Or you can think of the so-called sushi police program. So programs that tried to gently push restaurateurs, producers in a direction, but without being, you know, legally taking any of them to court. On the other hand, instead we have hard tools, so what can be more properly called the legal tools. So going to you know, with respect to specific jurisdiction, trying to protect a product, you know, under that jurisdiction, right? So since many here are Greek, so you can think of the case of feta, and we review a number of them, right, that are in that area. And an especially interesting area of this that we review in the book are those that in the very last section that we call empowerment. So they are all products, typically they are geographical indications that are protected in developing countries, or certainly communities that are least affluent. So basically, what did we do in the book? We tried to figure out how many, you know, what are the main issues, and we divided them up in this way. This is really the table of contents. Apologies, it's a bit tight, but we had, so the images, so the ways in which a food can appear, right? And we reviewed, we selected a number of cases in that area. These are not all the cases that there have been, you know, but they are the ones that to us seemed most significant. There might be others that also some of you can imagine, suggest. Then some are really related to the issue of whether a term is referring generically or specifically to a certain product. So take feta, right? But there were even recent issues in the US, for instance, with the what is it called, the um, I'm forgetting now the name of the this Swiss French cheese, will come to mind. That you know, whether something is a generic or specific, like, you know, and then Parmesan. And then we have some other cases where the language is, the issue is not whether it's a generic or a specific, but whether the language is you know, tricking the consumer. So there might be something in the communication that is you know, misguiding, and it's constitutive of the ways in which maybe the language is set up, right? So you could have a water that evokes perhaps a place, or a chocolate like the Maestro Swiss, or a coffee like Ethiopian, or a dispute, you know, like between the names of certain wines. Or there could be, in the fourth section, we look at procedures. So different kinds of procedures, and whether those procedures can be considered characteristic or not of a certain product, right? And so basically they're linked in one way or another to its identity, to its recognition. Then we look at issues instead concerned with the menus, so like menu scraping precisely, and recipe appropriation and forms of creativity, really the question that I started with. Then there are a number of other issues that we really saw as arising from the fact that a food is you know, shared across boundaries. right? And it develops across boundaries. So like you have basmati, right? Pisco, the manuka between Australia and New Zealand, and several of those have had legal, courts that had to decide. But these might be in some cases legal courts in different countries. Malaysia and Indonesia, for example, the Adang Krayan rice and rendang, it's there are two cases that are that involve the two of them. And they're quite interesting. Then we looked at issue of biotechnology, because of course they come to mind to a lot of people, and we thought maybe we didn't want to highlight them even too much, but clearly there have been some cases that have shaped the debates also around the IPs, like the Monsanto cases and these ones in the EU court on biological tomato, broccoli, and pepper. And as I said, then we looked at cases of empowerment. So again, as you see, we didn't, if you then look at actually the map of the cases, they are in all the continents. They look at quite different type of products. But what we tried to cluster them around are the types of issues that were elicited there, without looking in the specifics of what kind of IP was involved, but looking more at how the IP there was playing a function in connection to a certain food issue. So let's just give some examples, and then we'll open it up for discussion. The first thing maybe we should look at is when we mentioned the creativity in the kitchen, the most, I guess, trivial case is the one related to products. And here I think I'll leave the word to Enrico, if it's okay, Enrico.
Yes, this case, the chocolate bunnies case, was interesting because Lindt, the famous chocolate maker, tried to register as trademark the shape of the animal. In this case, for example, it was a rabbit, the little rabbit. Shapes might, in some circumstances, constitute a three-dimensional trademarks, a 3D trademarks, if the shape is distinctive enough to convince consumers, to allow consumers to distinguish that product from those of competitors. But in this case, the Court of Justice of the European Union confirmed that there is nothing distinctive in a shape of a chocolate. There are several producers in the market which use that shape, and therefore we cannot monopolize, because that's what IP does, no? Monopolizing, privatizing a shape for the use for just for one company, right? It would be dangerous from a competition perspective, right? And therefore the trademark registration was denied here for shapes which are considered common for chocolate products. But in the following slide, I want to introduce the issue of actually recipes, right? Can recipes be copyrighted? There have been a couple of more than two cases in America, especially. The United States is always very, innovative when it comes to legal decision and stuff. And in that case, basically, Barbour versus Ed. I just summarize very briefly the case. Judy Barbour wrote a cookbook called Cowboy Chew, and in 1988, so 36 years ago, signed a publishing agreement with a publisher, Cookbook Resources. And these two subjects, the chef and the publisher, subsequently sued two other people before the court of Texas, arguing that these people had published without their approval an internet magazine which included recipes virtually identical to those in the Barbour's cookbook, right? That was the claim in the dispute, in the action. So they said that this is copyright infringement. It is also an act of unfair competition. The recipes are copyrighted because they were accompanied by substantial literary expression in the form of explanations, directions, anecdotes throughout the whole book. For example, the phrase, the sentence, heat oil in heavy skillet, add the sugar and let it brown and bubble. this is the secret to the unique taste. No, that's what they thought it was a copyrightable element of the recipe. The court rejected these arguments, the arguments of the defendant, and found that effectively these recipes, or recipes in general, may, in some circumstances, contain elements subject to copyright protection, especially when they are arranged in a curated collection or conveyed through substantial literary elaboration. So an elaborated recipe could be and could attract copyright, right? And specifically, I quote from the court. The court noted the following: of the 20 recipes identified in the book as being identical or similar, this court finds that at least a few contain statements that may be sufficiently expressive to exceed the boundaries of mere fact. That's what is important in this decision. It is more than mere fact, because in other previous decisions, courts in America said, no, recipes cannot be copyrighted because it's basically a statement of facts. It's basically just a procedure, right? A set of instructions which gives information. But in this case, instead, the court went a step further by saying, no, it's not always like this. Recipes may be expressed in a way which is creative enough to attract copyright as literary work. So this case, this decision may open the way for other cases, no? In the future. It is a case of a few years ago, but still, chefs may rely on this precedent to claim copyrightability of recipes in the future, right? And in the following slides, we talk about more of transparency of communication. So there are other cases in the following slide. We can see some images. For example, this interesting case, Prosecco versus Prosec, right? Prosecco is the most sold Italian wine. The Italian version, cheaper version of champagne, no, we can call it like this. And of course, Prosecco is a PDO, protected designation of origin, is a form of GI protected in the European Union, strongly protected. And Prosecco Consortium recently opposed the application for another GI, European GI, made by some Croatian producers of Prosec, which is a sweet wine, totally different market from Prosecco, of course. Prosecco is bubble champagne for a category of consumers. Prosec is a Croatian sweet wine which must be consumed at the end of the dinner or lunch with the dessert, pudding, right? But of course, the Italians were quite annoyed about this because the visual and phonetic similarity between Prosecco and Prosec is quite evident, right? That's why we have decided to put this case in the language trap section. And then there is another case which we have highlighted in the book around the basmati rice dispute between India and Pakistan and also Nepal. Because basmati, I mean, most consumers associate, a majority, I would say, consumers associate basmati to Indian production, right? To Indian food. Actually, basmati rice, or different versions of basmati rice are also produced in Pakistan and also in Nepal, right? So the Indians filed a few years ago an application for registering as a protected geographical indication, another form of GI in Europe, the term basmati, the Indian basmati. But this application has been opposed by Pakistan and also Nepal, because they don't want to leave the monopoly over a very commercially valuable brand to the Indians. So we have decided to insert this case in the boundary section, right? Because here we have different countries claiming exclusivity over a traditional name. Let's remind that Basmati is not a geographical name, stricto sensu, right? It's not the name of an Indian or Pakistani region, town. No, it's not. It's a traditional name which is treated legally, at least, as if it were a geographical reference, but strictly speaking is not. But still, it's considered as an indirect geographical indication. The opposition is still pending. Pakistan has even filed itself another application for protecting Basmati in Europe. So it's, as you can imagine, it's also and predominantly not only a gastronomic or an issue about cultural heritage. Of course it is, but it is predominantly an economic issue, because having the monopoly in Europe, one of the richest markets in the world, having the monopoly over such an attractive brand would be crucial for each country, not any of these countries. So the dispute is really, really harsh. Another section of the book is about empowering, because we have analyzed in other section of the books, we analyzed the language traps, disputes between private producers regarding labeling, packaging, names of the food. But IP, and in particular geographical indications, may be used in the global south especially to distinguish local traditional products and to penetrate rich markets such as the European Union markets, which strongly protects IP, in particular geographical indications. And therefore, we have, for example, looked at Jamaica jerk. Jamaica jerk, as you can understand, is a geographical indication, again, protected just in Jamaica as GI, and it protects the way also of seasoning the chicken by using particular sauces and by using ingredients which are found there in Jamaica, and so on and so forth. And the idea is to protect, by protecting that name, to protect the heritage, the cultural, gastronomic heritage, and of course, economic interest as well. There are plans by the Jamaican Jerk Association, which is the consortium which manages such GI. There are plans to extend, to try to register the brand also in Europe, in the rich European market. At the moment, this is difficult, but I also talked with the people there when I did my research in Kingston, in Jamaica, and there is a firm intention by them to try to get the European Union GI title, because such title might also be used as a marketing tool, on the packaging, on advertising messages, by saying, look, our product has got the EU PGI, PDO, GI title that is used as a marketing tool. The same, as we will see in the next slide, exactly has been sought and is being sought now by South African producers of tea. And we are talking about the red bush tea, right? The red bush geographical indication has been registered in Europe, in the EU, as PDO, Protected Designation of Origin. It has been the first African GI being protected as PDO in the European Union. Again, what is the hope of the African producers, and also supported by the government here, local and central government in South Africa, to use such a title in order to be able to penetrate more effectively the European market by monopolizing a brand which has strict, firm links with the territory, because let's always remember that geographical indications rights are granted where the producers are able to show to the authorities which grant such title that there is a link, an essential link between the quality of the product and the local areas, the conditions of the soil, the climate, the geological, conditions, and also the local human resources, the local human, the local techniques, manufacturing techniques used for centuries and centuries. No, in this way, the idea is to protect the gastronomic heritage and also economic interest, because again, it is about monopolizing brands which may be valuable to consumers, right? And I will leave to you, Andrea, to finish the presentation by looking at the future.
Yeah, thank you, Ria. And so just to close, of course, these the list of cases that you have seen in the volume covers under each category those that seem to us the most interesting, exciting, fun to cover cases. But there are always a number of cases to come. So even at the end of the volume, we mentioned some of them. We mentioned actually these three. So a first one are NFTs used in the restaurant sector. And at this moment, as we're speaking, maybe NFTs are not the most exciting tool being used in a number of areas. Also in art, as they were important some time ago. But actually in the food industry, one of the sectors that is most lively, from this perspective. And this that I have here is a project that, a very recent project that is about precisely trying to build upon NFT, for recipes for restaurants. And we can imagine, envisage, we'll be happy maybe to discuss this also, a number of uses. Another one that it's quite, it could lead to interesting cases, the one of food delivery services, especially when you think of how some food delivery services, the person here in the picture now is Tony Delivers. I don't know if any of you knows of his case. Is a Seattle delivered that went in a sense solo, so it's like a single company delivering, single owned company, individually owned company that delivers. But you can imagine how these services, they had to grab menus from from restaurants and use them to advertise the products with methods and ways of communication, and in some cases were they are a bit disputed, but they never led so far, as far as we know, to specific disputes, but they could in the future. And at least the third area is the use of different tools, also tools in artificial intelligence in kitchen and robots in kitchen, so different forms of automation. Here I just put there was recently in Prague a workshop, a 2 days workshop organized on this topic, which followed actually a workshop that had been organized in California on the topic, if I'm not wrong, last year in 2023, and there will be a third one in Asia in a year. But certainly it's an area that deserves quite a bit of exploitation. It's relatively new, let's say, and there might be issues that arise in the future that could be interesting. Okay, I think it's good if we stop here. We look forward to any question, curiosity, discussion that we have. And thanks again for this opportunity to present. Here we had also our contacts in case you want to get in touch. And I didn't say at the beginning, also one thing, I'm directing, coordinating this group Culinary Mind of philosophers, and not only, actually Enrico is part of that too, they work on theoretical issues on food, and we regularly also organize seminars and other things. So it could be an interesting conversation between all of us. Thanks again.
Thank you very much, Andrea, and thank you, Enrico, for such a rich presentation, and also such a fantastic book, very rich and extremely, I think, interesting, but also important, so far as I can judge. The this will be a real hit in, I believe, and this is my evaluation and assessment in the IP studies. We have a little bit of time for questions, and until I wait some questions from the audience, I can kick off the discussion and the question myself. I found it very interesting, the issues of PGI and PDO, and we here in Greece and in the Just, we are particularly interested in this kind of strategies in let's say make intellectual property claims or claim a specific identity for a product. But I would like to start with you mentioned that you followed the societal juncture, and in approaching and studying for IP cases for the book. And while I have seen the disputatious dimensions, the corporate and market dimensions, I haven't seen any kind of ethical issues in all the cases or the topics and themes. And was this at the let's say center of of your approach? Was it a concern about the ethical dimension of the strategies of management of intellectual property? And the second question is that it seems that in your book you have an inclination towards the end product, the food as something that it is cooked. Although with the basmati is a little bit more complicated, but have you dealt with issues about plant breeders' rights and seeds and management of intellectual property in relation to seeds, and where you would categorize this in the soft, in the hard side of the intellectual property, and how this kind of intellectual property claims impact the food supply in contemporary and modern societies. Thank you for such a fascinating presentation.
Thanks, Tatis. I think both questions can be answered by referring to a section of the book, which is the section on biotechnology. Because biotechnology, of course, raises morality issues, ethical issues, and that to address the first question, but also the second question, of course, because about seeds. So one case we have looked at is an old case of 20 years ago in Canada. You may be aware, studies of the Schmeiser case, this farmer who happened to have his land next to the Monsanto plant, right? And what happened there, as you know, is that his land was contaminated with the GMOs, genetic, information. Basically, it's plants. The plants grown by that farmer Schmeiser had been contaminated, and therefore his plants had acquired the patented genetic information. But because of what? Because of crossing pollination and the wind, which favored the crossing pollination. And he was sued by Monsanto for patent infringement. And he lost, at least the injunction. He didn't have to pay damage. It lost because in patent law and in IP law in general, but in patent law, it's a strict liability. It's a strict liability sector. Let's say You are an infringer if you infringe. It doesn't matter if you want to infringe, right? Mens rea is not necessary to be condemned for infringement. Of course, it's important for damages purpose. So one may say, but it's paradoxical, it's absurd. Of course, it's many commentators have labeled this decision by the Canadian Supreme Court as an absurd decision. That's true, of course. I sympathize with this guy, but then if you read the decision in detail between the lines, you can understand that this guy realized that his plants had been contaminated by Monsanto. He got the crops, and then he stored the crops in his storage, and storing infringing goods under patent law is an infringement, right? Of course, this case raises ethical issues, right? And also other ethical issues have been raised by other cases, like the tomato and broccoli case. I'm sure you are also aware of this case before the European Patent Office. This method of breeding tomato with water content was patented by company, and therefore there is a provision which is not strictly speaking a morality related provision, but it's more technical. You cannot patent products derived from essentially biological processes. Basically, the aim is to prevent the monopolization of natural products where humans have not made so much, right? It's not strictly speaking morality related, but broadly it is, right? Because of course it's the nature which gives us the fruits. In order to make patentable an invention, you need to introduce some technical elements, which in that case, the broccoli tomato case was not really there. But this case law of the European Patent, this decision was from 9 years ago, 2015. This case law was defeated, was changed by a decision in the pepper case by the same office, the European Patent Office, in 2020, which completely changed by saying, no, you cannot patent products derived from essentially biological process, because there is a provision, it's clear in the patent, in the European Patent Convention. You cannot do that. You cannot really go around the prohibition by innovative legal interpretation of the provision. So in that section, yes, Statis, we do deal directly or indirectly with morality issues. I mean, GMOs, of course, raise such issues. I don't know if you want, Andrea, want to add some more philosophical angles to that.
Yeah, another a completely different answer probably from Enrico. This is why I think it's a nice conversation between the two of us. Is when we started thinking about the book, and organizing the materials, one way to organize the cases was also around philosophy. I mean, probably we figured they wouldn't have been so popular with a more general audience, also because maybe philosophers understand those distinctions, others don't. So it could have been, metaphysics, ontology, so where the identity, the essential aspects could be, or epistemology. I think in some cases, for example, if you're tricking consumers, if you're playing on consumers' expectations, then you're really dealing with epistemology. There could be some, it's about politics between countries. Some are really ethics. It could be the ethics of a producer, like an individual, owner of a small shop. Do you really wanna, go after your neighbor, or maybe your neighbor scraping off your menu, or appropriating of a recipe? Or think of cultural appropriation in many cases of recipes, even in cookbooks, is often dealt ethically, professionally. But then, despite the fact that I think it's difficult to assign one category to each case, and especially there may be for some all people in the audience will be over intellectual. The other thing that for me was especially fascinating was, maybe just given my naivety when it comes to to legal studies, is that you can start from a notion of justice that is like with a capital J, but then you can see that all of those issues actually really depends where you are, right? So is Feta Greek? It depends where you're speaking, depends where you're selling, and do you write with a capital F or or a small f? It really depends where you are. And so, as we said at the beginning in a couple of places, but especially also at the beginning of the book, I said we start from this notion of justice that is big, but that's not the road we took, because you see very quickly that if you are actually sticking to the law, justice with a capital J in a way crumbles, because you have to deal with specific legal system, and specific legal systems and specific sentences, and you have to take step by step and follow the law. So I liked that in a sense to use the law as you can see, of course, something that shapes markets, that shapes processes, cultural, social forces. And then it does intersect in many ways with our ethical intuitions, political intuitions, epistemic intuition. So that was the approach we took. But I can understand that you're saying, where is the ethics here? But I don't think you can, like, it's very hard to place it in one area, because even if you take one product, precisely like, feta, parmigiano, where is it depends where you are. Also, because depending where you are in the world, you actually have different names for it if you're following the law. Then if you're following your own personal language, it's if you're at home, this doesn't apply probably, it's a completely different sphere. So the sphere of agency for me here clearly emerges as key.
Can I intervene here, because this is very interesting, Andrea? Because here in our team and in Go Just, we study the issue of PTO and PGI, and we try to integrate in the approach the actors' categories, how the actors think and speak about this. And there, yes, you are right. There is a rather multiplicity of meanings of justice if you follow the actors categories and the actors concepts. Have you analytically followed this approach also in the book, or you just followed the logic of the law analytically?
Enrico, do you want me to go? I can, yeah. Well, I think we didn't divide by categories, because also there one difficulty, at least there was a slide when I showed the Ritter square, and then there was Fudgy the Whale and Easy Scoop, and the size of those companies, the positionality of these actors in a market is quite different, right? And I think if you are trying to do to go at it from an ethical perspective, you really have to be attentive to that. Take even menu scraping. One thing is it really depends who is scraping from what. Recently in the US context, for example, I've seen a number of discussions about Korean Americans taking Korean cookbooks recipes, or someone in the US publishing a book that was originally maybe in Korea, and the positionality is very important, right? So it was difficult within if we had to map it, to use that as a method of mapping, because then you'd have to follow their route, and it's really complicated to do. At least I wasn't capable of finding one that would have been intuitive with the cases we had. But yeah, I think it could make sense to look at that. That's what I do a lot of times myself, also in philosophy. Yeah. Sophia.
Okay, let's take some more questions. We have Sophia and then Vaso Karadzavelu. Yes, Sophia.
Yeah, Achilles has a question as well.
And
So
Achilles, maybe we can We can
I
read
haven't seen.
Achilles's question in the chat, Daphne, and then I
Okay,
can
yes.
ask mine.
Yes, I haven't seen that. So I'm reading Achilles' question. Do you think that at the certain point, climate change will destroy the authenticity and cultural identities, the things that make a product unique, even if we add practices such as animal or plant breeding, hydroponics, etc., will be still a local national tradition? Okay, she cannot speak. He cannot speak on the microphone, and he
I have
will
a
catch for
very
this.
quick answer to that, which is to make a reference to a paper also I wrote like 1 or 2 years ago with two colleagues, Nicola Piras and Beatrice Serini. That is precisely on this, looking at it's called hot grapes, is the problems of relocation or imagining possible futures for, in that case was for wine GI products, you know. So think of even the case of champagne. Some people said, "Oh, let's go to Norway or England." You know, in some cases we go with genetic modification, or you change the area of production, or you change what happens in the cellar. So there are different strategies that people are thinking with to address climate change. But this is certainly a problem. You know, like something that deserves. We cite it also in the book. I'll just post the reference here. But yeah, clearly, I think Achilles, this is a big problem. Some traditions the product might not survive at all. You know, even cocoa, perhaps, or some products might just go extinct. So it's not even a matter of the plant, the very plant or the animal. Yeah.
It's okay, I can ask a question. First of all, yeah, thank you very much for this excellent presentation and for this super interesting book that you created for our community. I'm very excited to read it. But because I'm also impatient, I would like to hear a little bit more about the meat cases. You talk a little bit about the heme molecule under biotech section and also about beyond. And I was wondering if you could just give me a little preview of what those chapters are about. So that's my first question. Thanks.
Enrico, do you want to go? Do you want me to go?
You're muted, Enrico.
We cannot
Sorry,
hear you.
the volume was a bit low. You were particularly interested in the heme case.
The heme case and also beyond meat. You had
The beyond meat. Yeah, the beyond meat is very because it's very interesting. Basically, Beyond Meat is a food processing company which was founded in 2009, a US company. What they do, they basically do plant-based alternatives to beef, to pork, to poultry. They have registered recently more than 100 trademarks in several countries, consisting of words like beyond meat, beyond sausage, beyond bacon, beyond chicken, beyond jerky, beyond crab, beyond shrimp, beyond tuna, beyond deli, beyond balls, beyond brunch, beyond eggs, and several others. We in reference to meat substitutes, right? So what is the aim of this trademark strategy? To replace concepts typically associated with animals, with the concept instead of plants, by means of a food technology. And of course, they want to monopolize, right, these expressions to prevent competitors from using this science in the marketplace. Basically, their mission basically is to commit to a very quick and relentless innovation means to bring the world's best plant-based meat products to the consumers, right? However, for example, the Beyond Meat Burger trademark in Japan, written in katakana, Japanese character, was basically opposed by a company in Japan because it was another company, another US company, because they said it's identical to my Beyond Meat. It was an identical earlier trademark. The Japanese Trademark Office recognized that the applicant, Beyond Meat Incorporated, the first, had established a significant level of reputation as producer of plant-based meat replacement, also in Japan, in that country. And the Trademark Office concluded in these proceedings that the two marks were similar and therefore cancelled the trademark Beyond Meat Burger. Well, basically, what this case shows is that, these effective strategies, this strategy of trademark filing and enforcement, which aim at monopolizing brands, taking the concept of animals out of the food system, right? And we also believe that this case is a kind of school example, a textbook classic for debates in food ethics, right? I don't know here if you want Andrea to expand on this food ethical of this case.
Yeah, we covered this because we know that precisely people also like you, Sophia, they are working specifically on meat, or be interested in this area, and probably meat might be, as far as I can tell, maybe this could be the best, but it's one of the areas where actually IP laws are being more than in other areas to push a big change in the market, right? So instead of buying just a product based on the type of meat, like poultry, pork, beef, you're actually buying a brand, like you do in lots of other things, right? So I think this is the model towards which a number of these US actors tried to, that's the direction they tried to go some years ago as we were writing this. Now it's probably shifting a little bit, but I still see a very strong brandization, what would you say, of the product. That it wasn't the case. Maybe before it would be like a local chicken, or organic chicken, but not, from a specific producer, right? And all of this is what we also to emphasize there is that this is covered, right, by IP laws allow this. And then what they could allow is seeing these protein products, right, as having something in common that is related just to the brand. And so it could even be in the future, or that's the direction that one is pushing, is that all of these protein products, they share the fact that they come from the same brand, so they share maybe an underlying technology. And maybe in the past it could have been they're all organic, but it's hard, even I don't think it was going in that direction, the market. So here it's a case where the legal aspects might help shape the market very strongly in a certain direction. And the him case was I think a specific study of that. What we thought is we would have liked in the process maybe to put also something that was precisely more technology innovation related. So him being just related, a classic case where you have a patent and you're trying to outcompete the other new people in the market that arise, and I think it's still pending. I don't know if that case, but it's clearly a case of that sort. It just shows how feisty it is right now, that market. Then I know you are working specifically on this. You probably have lots of other things to add.
And Sophia, so the Japanese Trademark Office here basically sided with this plant alternative company by saying, look, you have a monopoly over 100 trademarks like this, and you are able to prevent meat producers to registered something similar or identical to you. In Europe, plant-based producers have been less lucky, I would say, right? Because of course, you are aware of the decision of the Court of Justice of 2017, or you remember, Andrea, we commented on the vegan
The packaging, the vegan
packaging,
diaries, yeah.
The diaries. Basically, in Europe, there is more, I would say, reluctance to please that industry, the plant-based industry, because they say, look, the plant-based industry, they want to appropriate packaging like of the milk or the vegan burger, right? Or to kind of lure consumers. Look, consumers, we are selling something similar to meat, but it's not meat. And European authorities are quite strict because they want to prevent consumers' confusion. And to be honest, speaking with the normal people in the street, when I spoke to my mother about these cases, oh my God, last week I went to the supermarket. I made a mistake. I bought the wrong product. I wanted to buy milk. I bought the wrong milk. So it happens. Consumer confusions happens because of these strategies.
Yeah.
And the Court of Justice, the European Union institutions, they want to prevent that.
Yeah. Just to jump in, because I know we're over time, so I just a short comment, but I think this is super interesting. Just to connect to Achilleas' previous comment, climate change, etc., and on perhaps wanting to promote a kind of plant-based diet and transitioning away from meat, or at least overconsumption of meat and dairy, etc., in Europe. One might imagine a kind of situation where this is just like there is a leeway given for replacing these products that we want to phase out. Should we decide as societies that we want to transition to this? I wonder if that's like a new area in this type of work where substitution or replacement might want to be encouraged by legislators or by governments, and how that might affect like IP, or how might that affect this type of work so far. This is kind of an open question, but this is an important moment in time where replacing, substituting, transitioning, like all these words are like all these concepts are coming into our experience and into our vocabularies. And it's interesting to think about how or whether that might be facilitated legally, or into different types of frameworks, and what type of instruments might help do that. So it's a very, philosophical or more abstract question, but we just wanted to throw that in there for our reflection.
Yeah, I think this is great. Just as 30 seconds, this is great, and from what I could see and so far is that in fact there are these two different, for me, the areas. One is the brandization, right, issue, and the other one instead is the is whatever are the grounds for identifying something as a product as something. So take the biotech cases, the essentially biological tomato and pepper. That's more like about just identity. It's not related to brand exploitation, but it's related to what's the identity of a product, right? So what is meat? What is milk? What is a tomato? And those are really about the genericity, and how do we define that, and how we want to conceptualize them, and whether the law is the way to go, or if we need to exploit a different, manner. I think with the law, what you can see is that because it has to be consistent, if you go one direction with meat, then maybe with tomatoes, you've got to do this. So, and sometimes you may want to go, ethics could tell you, oh, go in this direction with one product, but another with that. And I think the law might tell you that's inconsistent. That I think that's what I could see, but of course this is a much.
I'm involved in a project now on meat replacements, and which is led by a legal scholar, and she's been working on human rights, but her approach to this topic about meat replacement fusion is thinking about rights to sustainable food. And so kind of it's not from the IP perspective, but like rights to thinking about for so yeah, well,
I
big
can see
discussion,
that
but
being promising. Yeah, more than IPs. Maybe IPs is not the, but maybe, but I don't know. Certainly this is something we could explore.
Although we are over time, we are closing with the question by Vaso, who is an expert on olive oil and PDO and PGI. So not from a legal point of view, but more from the anthropological and sociology of science and technology point of view. But in her project. She deals with PDO and PGI. Yeah, please, Vasu.
Hello. First of all, thank you for your interesting talk. In fact, my question is included in your response to Achillea's question regarding traditionality and how it is incorporated in PDO and PGIs in terms of the technological changes taking place these days. And I would also like to ask, looking into olive oil and whether you see tensions towards incorporating science and legal stuff in geographical indications and traditional certifications, because we are looking into such issues very closely. And I think that it's a growing trend towards creating new identities for products that include both legal aspects and, let's say, technological certifications on authenticity and traditionality related to specific areas and islands, let's say Lesbos in Greece. So I would like to ask if you have experienced something similar in your cases.
Enrico, so do you want to go?
If you can go first, then I can say something later.
Yeah, sure. I mean, I think in the book, the closest we get to that, if I can think correctly, are just the cases of the tomato, peppers, the tomato, broccoli, and peppers. But they're not the most interesting from the point of view of traditionality. So some other situations that have not been given rise to court cases, but I can see them as a tendency I see, at least personally, as problematic in other parts of my research, is that to define a traditional product by means of, for example, a certain genetic profile of some yeasts or some microbes, to me runs the risk of, because those yeasts and microbes ultimately they're definable independently of place and space. So the risks are two. One is that you essentialize the identity, that I always think, maybe in the short run it's okay, but in the long run, maybe, then it could have negative effects. The other is that it might also give reasons for lifting the arguments of identity as with respect to place. I see this happening a lot also here in Italy, but in other places as well. So at that point, take the product I mentioned before was Gruyere. If you think Gruyere is specific because of some genetic strain, aspects of some microbes, then maybe you could produce those anywhere else on the earth, maybe even outside of the earth, and it's still Gruyere. Why not? It has those aspects. So even though maybe today you cannot do that, it could be that in 5 years you can do that, and then you really open the door to say that's the same product, right? Because if it has those so it was actually one of the earliest topics that I studied, coming from philosophy of biology, metaphysics, philosophy of science, and that's the risk I see. I don't know if he answers, but I'll be happy to talk more actually about this.
No, Andrea, that was really a complete answer because, and Vaso knows very well from recent interviews, we have found this in the case of yogurt, Greek yogurt, that it is produced in the United States, and this is what we are studying in one of the cases, through microbes that they are collected and registered from a research lab here in Athens, but then since those can be sold in different places, you can produce Greek yogurt everywhere. So in the way there was a detachment of the authenticity and the locality through what you have just described. Yes, and this is very helpful for our work here in what you have just described here in Athens. Yes, because we study particularly this case. Yeah, very, very interesting. And sorry, Enrico, you are closing.
No, on the Gruyere case, that's very interesting because there was a decision by the US Trademark Office, by the judge, sorry, in America last year, saying that Gruyere had become generic for a type of cheese, which is not uncommon because, you know, Americans, they don't like GIs, they don't like monopolies over names on traditional products. I remember in 1984, there was a decision from the Trademark Office in the US about Fontina, which is an Italian cheese. Fontina is a town, is a little town in the northwest of Italy, Piemonte, no, Val d'Aosta, in the Aosta Valley. Again, because it was considered generic. But here there is, as you can imagine, there is not only a legal divide, but also a cultural divide. Most consumers in America don't know that Parma is a town in Italy, that feta is the cheese. I mean, they don't know. And therefore, this ignorance, without offending anybody, but this ignorance meant by the not knowledge, the lack of knowledge about geographical place with the rich gastronomic tradition leads to these decisions, right? It's the legal decision is a consequence of a lack of knowledge at the end of the day, right? So it doesn't surprise me, of course, but at the end of the day, it's, as I wrote in several papers, it's a kind of a fight between the old world, Europe, with strong gastronomic culture and tradition, and the new world, the US, Canada, Australia, where, you know, you can have Australian Prosecco. There is another case I have commented about the Australian Prosecco, which they are losing lots of sales because of the Prosecco strategy, the Italian Prosecco Consortium strategy to get protection in Japan and all over the world. Of course, this means less sales for the Australian Prosecco. But, you know, the EU is quite aggressive. We know that when it comes to exporting their strong GI rules abroad in FTAs, on free trade agreements. They need to accept that. I mean, at the end of the day, IP is a policy tool, right? And the EU is using IP, GIs, to export, to boost exports, right? In the very same way, the US government is pleasing the pharmaceutical industry to try to get more patent protection for their pharmaceutical industry abroad, or for Disney, for Mickey Mouse, you know, in Australia, trying to extend the copyright for 150 years over Mickey Mouse. You know, each block, at the end of the day, use IP to protect their own interest. And that's what the EU is doing with protecting feta, Parmigiano, beyond Europe, right? It's a kind of risico war between the blocks, right? So at the end of the day, that's international trade, no? That's every block looks at its own interest, right?
Okay, and with this, we would like to thank you both for such a fascinating presentation, book, and also a fascinating discussion, I believe. We are already half an hour beyond what we have agreed, and we would like to thank you for giving us your precious time. It has been an honor and a pleasure to host you both. Thank you so much, and wish you all the best and best luck to the book, which is a fascinating study, I'm sure about that. And thank you so much.
Thank you for having us. Look
Thanks.
forward to continue talking.
Thanks.
Ciao.
Kalispera. Kalispera.
Kalispera, yes.
Kalispera. Bye bye. Thank
Bye.
you. Bye, everybody. Thank you so much for being with us. Bye.